this afternoon. The judgment is contained exclusively in the full written judgment, copies of which are available, and the judgment will, in the normal way, be posted electronically. The neutral case citation number is 2025 EWCA Civ 1311. There is a written press summary available for all as well, and the documents will be distributed in the normal way at the end of our summary of the decision. This appeal concerns the challenge to the order made by the Secretary of State for the Home Department adding Palestine Action to the list of proscribed organisations contained in Schedule 2 to the Terrorism Act 2000. Ms Ammori, one of the founders of Palestine Action, brought a claim for judicial review in the High Court, challenging the lawfulness of the decision to proscribe Palestine Action. The judge below, Mr Justice Chamberlain, decided that the claim could proceed by way of judicial review in the administrative court. He held that the possibility of Palestine Action applying to the Secretary of State to deproscribe, that is, to remove Palestine Action from the list of proscribed organisations, coupled with a right of appeal to the Proscribed Organisations Appeal Commission against a refusal of that application, was not an adequate alternative remedy to judicial review before a judge in the High Court. He granted permission to apply for judicial review on 2 grounds, but refused permission on 6 other grounds. Subject to the outcome of this appeal, the hearing of the claim for judicial review is expected to take place next month in November 2025. The Secretary of State appealed to the Court of Appeal, contending that the ability to apply for deproscription with a right of appeal to POAC was an adequate alternative remedy for challenging the continued proscription of Palestine Action, such that the claim for judicial review should not be allowed to proceed. The appeal before us was therefore concerned solely with the question of whether the challenge could proceed by way of judicial review in the High Court at all, or should be considered by the Secretary of State, with any appeal being heard by POAC. So the appeal before us had nothing to do with the substantive merits of the challenge. In our judgment today, we are dismissing the appeal, holding that Ms Ammori can bring her challenge to the initial decision to proscribe Palestine Action in the High Court by way of a claim for judicial review. We are holding that an application to proscribe with a right of appeal to POAC was not intended to be a means of challenging the original initial decision. Sections 4 and Sections 5 of the Terrorism Act 2000 were not intended as a means of challenging the lawfulness of the initial decision to proscribe. We go on in our judgment to hold that in any event, even if such an alternative remedy had been available, the judge was entitled to conclude that such an application was not an adequate remedy in the circumstances of this case. Judicial review would be a quicker means of challenging the order prescribing Palestine Action. Judicial review would enable the High Court to give an authoritative judgment on the lawfulness of prescription. That judgment could then be relied on in criminal courts hearing charges against any person in connection with their support of Palestine Action. Quite separately, we also heard an appeal by Ms Ammori against the judge's refusal to grant permission to rely on 4 more grounds of claim and an associated application for an extension of time in which to make that appeal. We are granting the necessary extension of time, and we are then granting permission to apply for judicial review on 2 of those 4 grounds. Those two grounds are whether or not the Secretary of State had had regard to relevant considerations and whether or not she had complied with her own policy. These two further grounds will now be the subject of legal argument and evidence at the hearing of the claim next month. Permission to appeal on the final two other grounds was refused on the basis that they were not arguable. As we have said, the judgment is contained in the written judgment, the full judgment, and there is a press summary. The parties have very helpfully, in short time, agreed a draft order for which we are grateful, and we make an order in the terms of the draft agreed between the parties.
Thank you.
Yes, thank you all very much. I know that you have been working under pressure as always, and thank you again for your assistance not only over the last few days but also during the course of and before the hearing itself. Thank you very much, my lady.
Court rise, table.